This is meeting number 23 of the Standing Committee on International Trade. Welcome to all the members and to the guests that are with us today. Pursuant to the order of reference Monday, February 2nd, 2026, the committee is resuming its study on Bill C-18, an act to implement the Comprehensive Economic Partnership Agreement between Canada and Indonesia. We have with us from the Canada Border Services Agency, Maida Christina Horzak, Executive Director, Commercial Trade Policy, Department of Finance, KRSE, Analyst Economist, International Trade Policy Division. From the Department of Foreign Affairs, Trade and Development, Aaron Fowler, Associate Assistant Deputy Minister, International Trade Branch and Chief Trade Negotiator. And Raoul Watchmaker, Deputy Director and Senior Counsel, Trade Remedy Law, Trade Law. Beautiful. You guys should get a real short term for all of these names here. They just keep getting longer, which I guess is a great thing for you, just longer for the rest of us. And Lucas McCall. And from the Department of Industry, Mehmet Karman, Senior Policy Analyst, Investment Review Branch and Economic Security Branch. Thank you all for being with us today. A reminder to committee members that officials are present to answer questions that any of you may have in regards to the clause-by-clause consideration. And just as a reminder, I think everybody remembers, since we just did C-13 last week, I'm not going to read this out a whole lot because I think everybody knows what the procedure is. I will read out each clause successively, and you have a number on each clause. In addition to Block 1 as an example, you also have another, I think it's a 6-digit number. I will reference that number in order to ensure that we are all referring to the same amendment that's being proposed. And again, the amendments are going to appear as they were given to us. They have been properly drafted in the legal sense, so amendments must also be procedurally admissible. I will call upon to rule amendments inadmissible if they go against the principle of the bill or beyond the scope of the bill, both of which were adopted by the House when it agreed to the bill at second reading. So we will move forward with our officials that we have here. Yes. All right. All right. Pursuant to Standing Order 75-1, consideration of Clause 1, which is the short title, is postponed. I therefore will Clause 2. There are no amendments proposed from Clauses 2 to 15. Is there unanimous consent to group them for the vote? If yes, sorry.
Ça un peu vite. Je voudrais demander d'abord à nos témoins qui sont experts, étant donné que, surtout aux avocats du ministère, vous n'avez pas d'interprétation. Vous avez-vous?
Do you have interpretation? Do you have interpretation? Is it working? Can you hear me? I'll wait.
You start that again.
Oui. Juste avant, parce que
just before, because it started a bit quickly, because there's a lot in legal language that we're not all experts on. I'd like to ask our legal experts if they can tell us what specific paragraphs establish the relevant regulation.
Madam Chair, I'm not certain I understood the question. Paragraphs of the bill, clauses that are being proposed for amendment. What?
Could you elaborate a little bit more, Mr. Savard-Tremblay?
Ben, écoutez, je sais pas comment l'expliciter.
I don't know how to make the question more explicit. I'd like to know what aspects of the law, which paragraphs in the law establish the state investor principle and activate the application for Canada. The dispute settlement mechanism.
So I understood the question to be about the investor-state dispute mechanism. So the clauses of the bill that activate the investor-state mechanism for disputes under the Commercial Arbitration Act are the amendment in the bill that are specific to that act.
Oui, mais puis-je savoir lesquels dans le projet de loi?
Yes, but can I know which ones in the bill?
Or I believe it is clause 26.
Donc, loi sur l'arbitrage commercial.
So on commercial arbitration 26, is that it?
Yes, that is the only clause in the bill related to ISDS. Yeah.
Donc, le numéro 27 qui est sur le tribunal.
So number 27 on the Canadian court, that's something else. That's on the dispute resolution mechanism?
No, the clause that deals with the Canadian International Trade Tribunal principally implements the agreement, the provisions in the agreement that have to deal with things like bilateral safeguards and safeguard exceptions and the such. So matters that are normally considered by the Canadian International Trade Tribunal.
Je vous remercie.
Thank you.
Continuez, madame.
So we can move forward. Thank you.
Yeah. So I had read out the amendments from clauses 2 to clause 15. Is there unanimous consent to carry them for the vote? If yes, is everyone in agreement with clauses 2 to 15? Yes? Yes, okay. So clauses 2 to 15 have carried. Okay. Monsieur Tremblay, we have a new clause presented by you, 15.1. Would you like to move it, sir? And that, just so we're very clear, I'm referring to block 1, and in the top left-hand corner of your page, you have the numbers 138-98243. That is the amendment that we're talking about. Let's make sure we're all on the same page. Okay? Block 1, 138. There were some changes to it. So I just want to make sure everybody's got the same pages. 138-98243. Top left-hand corner of the proposed amendment. Okay, all right. If you'd like to move that proposed amendment, Mr. Savard-Tremblay?
Yes.
Do you wish to speak to it at this time?
Oui, écoutez, c'est dans l'idée de...
Yes. There are some considerations, always wanting to promote trade. There were considerations regarding the state of the environment in Indonesia and human rights linked to a certain industry. It was so serious that Switzerland and Europe has a watchdog related to it. So I think it would be good to have an expert group that looks into it and can report back.
Thank you very much. In reference, though, to that particular amendment, Bill C-18 seeks to implement the Comprehensive Economic Partnership Agreement between Canada and Indonesia by approving and enacting this agreement. The amendment attempts to force the minister to appoint an expert group responsible for the evaluation of compliance of Indonesian companies operating oil palm plantation whose products are imported into Canada. As our House of Commons procedure and practice, since an amendment may not infringe upon the financial initiative of the Crown, it is inadmissible if it imposes a charge on the public treasury or if it extends the objects or purposes or relaxes the condition and qualifications. So I therefore am ruling that particular amendment inadmissible, sir.
Je serai donc forcé de contester votre décision.
I will have to contest your decision.
All right, then I will ask the committee. I have ruled the block motion inadmissible. Those who support my ruling will say yes. Those who do not support it will say no. So, Mr. Clerk, would you please call it out?
Thank you. So the question is, shall the decision of the chair be sustained? Mr. Fonseca?
Yes.
Madame Lapointe?
Oui.
Monsieur Lavoie?
Oui.
Mr. Nakvi?
Yes.
Mr. Chambers? No. Mr. Stevenson?
No.
Ms. Goodridge?
No.
Mr. Mantle?
No.
Mr. Saval-Tremblay?
Non.
Right. Well, thank you all very much. The next step, then, do you want to speak further to
Non, je crois que
No, I think the amendment was. I don't think any further explanation is necessary.
So we will now call for a vote on. I'm sorry, say that again?
I'd like to speak on the.
Oh, okay. Anybody? Yeah, that's right. We should have a debate on this now. Yes, Mr. Mantle.
Thank you. Actually, just a question to the panel. You've seen this amendment and other amendments from my bloc colleague on similar issue. Do you have any comments on the substance of this in terms of what Canada is or isn't doing with respect to either environmental concerns or specifically palm deforestation in Indonesia, which is a well-documented concern worldwide?
Alan? Yes, I am. Okay. Thank you. Madam Chair, I thank the member for the question. I think there are two or three elements that are relevant to the amendment that's been proposed. The first is the substantive provisions that are contained within the agreement with respect to the treatment of palm oil, and then the mechanisms that exist already both within the agreement and outside the agreement to manage concerns of the nature that I think this amendment is intended to address. The agreement does not change the market access situation for Indonesian palm oil into the Canadian market. Canada has a 6% most favored nation tariff rate on imports of crude palm oil. We are not reducing that tariff at all as a result of this agreement. That tariff line is excluded. Canada does not apply an MFN tariff on imports of refined palm oil from any source, and that will not change as a result of this agreement. But even with that MFN zero rate on refined palm, I think it's important to note that in 2024, Canada imported only about $55 million worth of palm oil from Indonesia, and that accounts for less than 1% of Indonesia's global exports of palm oil. So we are a relatively small and marginal importer. The CEPA does nevertheless include strong mechanisms to address trade-related environmental and labor matters that may arise between Canada and Indonesia, including any that could be potentially related to bilateral trade in palm oil. The Agreement's Subcommittee on Environment, the Agreement's Labour Council, allow Canada and Indonesia to advance the Agreement's commitments on matters such as sustainable agriculture, sustainable forest management, as well as the elimination of forced labour and child labour. And the agreement contains robust consultation mechanisms to resolve any environmental or labour matters that may arise. If the parties continue to have divergences in position, there is a dispute settlement mechanism that would enforce the parties' commitments in this respect. We also have strong mechanisms outside the CEPA that help to deal with any sort of issues of this nature that would arise linked to the importation of palm oil. I'd be happy to elaborate on what some of those are if it would be useful to the committee.
Thank you. That's sufficient at this time.
Oh, I'm sorry.
Est-ce que il y avait
There was a CBSA rep. You? Yes. Can you tell us how much cargo was seized over the last few years because they violated human rights? I don't have an answer for you on the spot. Well, I'll look it up. That's too bad, because that could show us the extent to which this model doesn't work, because there have been studies on this. We've proved it doesn't work. So to be told that there's, quote unquote, only $50 million of palm oil, but that we have dispute settlement mechanisms, etc., everything is fine, when we examine the broader scope of the question there's no real filter.
Thank you very much. Further discussion, Mr. Mantle.
Thank you. I'm taking advantage of you being here, sorry, but my block colleague's question reminded me of another issue on information and data forthcoming from the CBSA. The committee will recall that other members of the CBSA were here, and we had asked about goods that were detained because they were produced in whole or in part by forced labor, and the written response back to the committee was, I'm sorry, we can't give that information to you. So I'm wondering if you would comment on why the CBSA feels it's unable to provide the committee details on goods that arguably, or at least on the CBSA's own admission, may violate Canadian law, but that information is not able to be provided to the committee.
I am not able to provide it immediately, but I will be able to search for it and provide it.
Let me just say, I've been down this road before, where we get a response from the CBSA with some reference to either its privacy concerns or a piece of the Customs Act that they think they can rely on. I'll just say that if information is not forthcoming, more production orders will be moved by myself at this committee.
Any further discussion? Calling for a vote on Block 1. All those in favor? Mr. Clerk?
Vote on BQ1. Mr. Fonseca?
No.
Madame Lapointe?
No.
Monsieur Lavoie?
No.
Mr. Nakvi?
No.
Mr. Chambers?
No.
Mr. Stevenson?
No.
Ms. Goodrich?
No.
Mr. Mantle?
No.
Monsieur Saval-Tremblay?
Oui.
Oh, it is not adopted. All right, on to Block 2. Mr. Savard-Tremblay, would you like to speak to Block 2, please?
Écoutez, j'en ai préparé une que même vous allez sans doute.
I prepared one that you will surely think is admissible. This time, it's a motion that doesn't involve an expert group, but rather ensures an annual follow-up from the department or the minister in order to ensure that there haven't been any violations, in order to uphold transparency. And I moved similar motions regarding the agreement with Ukraine. At the time, my Liberal colleagues approved of it. So this is really about transparency and follow-up. And as the high civil servants have told us, if everything is really going well, then we'll be able to make sure that's true.
Amendment. Is there some further discussion on... I'm going to rule that it's admissible. And is there any discussion or debate on this before we call a vote on Block 2? Mr. Napke.
Thanks, Chair. I was just going to go to Mr. Fowler perhaps again, and if he can give us his thoughts on this particular recommendation. I noticed that it relates to palm oil industry. I'm assuming your rationale will be pretty close to what you outlined in your previous response in terms of the impact of that particular sector, that industry, on Canada and within the Canadian market.
Thank the member for the question, Chair, and yes, I can confirm that the information that I think is relevant to consideration of this amendment is the same as the information that I read into the record for the last proposed amendment. Thank you.
Any further discussion, Mr. Chambers, and then back to Mr. Savard? No? Okay. Mr. Savard?
Non, je mentionnerai.
I just mentioned that if all is well, then we'll be reassured annually. then if all is well, then we'll be reassured of that fact annually.
Bit of a problem with the translation here today.
Là, je mentionnais tout simplement que si tout va
I was just saying that if everything is going well, then we have nothing to lose for the minister to give us an annual report.
Thank you. All right, we'll now call for a vote on Block 2.
Thank you. The vote is on Amendment BQ2. Mr. Fonseca?
No.
Madame Lapointe?
No.
Monsieur Lavoie?
No.
Mr. Nakvi?
No.
Mr. Chambers?
No.
Mr. Stevenson?
No.
Ms. Goodrich?
No.
Mr. Mantle?
No.
Monsieur Saval-Tremblay?
bien sûr.
It's defeated.
Okay, so does not carry. All right, now we have amendment proposed Block 3. Would you like to speak to it?
Oui. Ben alors, écoutez,
Well, now we're getting further away from the palm industry, and we're going to zoom out on human rights generally, as was explained, and it was similar to the agreement with Ukraine that received almost unanimous consent, if I remember correctly. So we're starting with the expert groups, and then, given that you will say that it's inadmissible, I'll leave it up to you. We can then move to the next motion.
All right. Any further discussion on Block 3? But before you have any more discussion, just so you know that I'm ruling it inadmissible, as you probably already know that. It imposes a charge on the public treasury as it extends the objects or purposes or relaxes the condition and qualifications specified in the royal recommendation. So I have ruled that it is inadmissible. Okay, thank you.
oui, je conteste.
I challenge.
All right.
Thank you. So the chair's ruling has been challenged. So the question is, shall the decision of the chair be sustained? Mr. Fonseca?
Yes.
Madame Lapointe?
Oui.
Monsieur Lavoie?
Oui.
Mr. Nakvi?
Oui.
Mr. Chambers?
No.
Mr. Stevenson?
No.
Ms. Goodrich?
No.
Mr. Mantle?
No.
Mr. Saval-Tremblay?
Non.
Chair, the decision is overturned.
All right. So should we, is there further discussion or debate on this before we vote on it? Mr. Mantle.
Thank you, Madam Chair. Again, I'm going to take the opportunity, because we have our panel of experts here. Article 22.5 is in the SEPA. It's what you probably refer to, or I've referred to, as full of a lot of hortatory language. Would you agree with that assessment?
I'm just reading the text now, and then I'll. I think that is a fair characterization of the obligation.
It creates no enforceable obligations subject to dispute resolution or requiring changes to Canada's domestic law.
That's correct.
So I guess my question then is, why do you agree to put these provisions in? They don't seem to mean anything.
We put them in because they establish a set of expectations that both parties share with respect to how enterprises from the two parties carry out their operations under the agreement. Because that agreement is trade liberalizing, it removes certain market protections that would otherwise have applied. We like to have a means by which to take up issues related to the responsible business practices and generally the business practices of enterprises of the other party that are operating in our territory. This creates an opportunity for us to do so under the various institutional bodies that we will establish under this agreement. So it creates the expectation, and it provides us with an opportunity to discuss any related issues within the institutional structure of the SEPA.
Okay, I would suggest that those opportunities exist without writing out language that creates no obligation. I mean, in law, you say if you have no right if there's no remedy, and there's no right or remedy included in these provisions. Would you consider the inclusion of additional industries in the core to be a potential way to address these, at least domestically? The core being the Ombudsman for Responsible Enterprise, which can investigate Canadian conduct abroad, but currently does not include agricultural sectors. It's only garments, mining, oil and gas, etc.
I think I would need to consider that proposal in the context of how the core operates presently. Obviously, it's not a question directly linked to the bill that's before the committee today, so I will defer, but consider the question.
Fair enough.
Any further discussion, debate? All right, I'll call block 3. Just so everybody knows exactly which one. The number beside it in the top left-hand corner is 13898120. All right, so I've called for a vote. Mr. Clerk?
The vote is on Amendment BQ3. Mr. Fonseca?
No.
Madame Lapointe?
No.
Monsieur Lavoie?
No.
Mr. Nakvi?
No.
Mr. Chambers?
No.
Mr. Stevenson?
No.
Ms. Goodrich?
No.
Mr. Mantle?
No.
Mr. Saval-Tremblay?
Oui.
All right, we'll move on to block number 4. If you'd like to speak to it, Mr. Saval-Tremblay.
Alors, étant donné que
Given that there won't be an expert group, I hope that we can at least trust the administrators to send us a proper report. Here, once again, what worked for Ukraine should work for Indonesia. If it doesn't, then I'd like an explanation, especially because there are colleagues across the way that aren't saying much today.
All right, I don't know if any of our experts who want to speak to block 4 and answer to Mr. Savard-Tremblay.
Thank you, Chair, for the opportunity. Again, I would simply draw the committee's attention to existing mechanisms outside the CEPA that I think are intended to address the issues that are related to the amendment that's been moved. For awareness, although I'm sure the committee is already aware, Canada does maintain a national contact point, which is a government-backed office that promotes responsible business conduct under the OECD guidelines for multinational enterprises on responsible business conduct. This is otherwise known as the OECD guidelines. These guidelines set clear international standards on issues like human rights, labor, the environment, and anti-corruption. National contact points are part of a global network that provide a platform for collaboration and coordination between countries, including on cross-border cases in respect of these issues. NCPs, or national contact points, provide a free, impartial, non-judicial dispute and complaint resolution mechanism where communities, workers, or other stakeholders can raise concerns regarding potential non-observance of the OECD guidelines. Canada's national contact point could, for example, hear complaints regarding issues arising in Canada or by Canadian companies operating in Indonesia. The process follows internationally recognized principles of transparency, fairness, and accountability. Thank you.
Much. Any further questions or debate? No, not seeing any. I will call. Oh, sorry, Mr. Mantle.
What action can the national contact point take if they receive a complaint about the conduct of a Canadian enterprise overseas?
Thank you for the question. We're going to have to identify the specific actions that are within the remit of the national contact point. And we will come back to you maybe as early as later in this session, but I don't have that information immediately at hand, and I would hate to mislead the committee by speculating inaccurately about the actions that are within their authority.
Fair enough. In your response, it'd be helpful if you could provide examples of, anonymized, however you want to provide them, of what actions the national contact point has taken, because I think you'll find that it's none.
Mr. Savard Tremblay?
Donc,
I'll sum up the responses. So we don't need this amendment because there are already mechanisms, there are already ways to do it, but they don't know what to tell us.
Okay. On the floor? No. All right, so Mr. Kerr would call for a vote on Block 4.
All right. Vote is on Amendment BQ4. Mr. Fonseca?
Yes.
Madame Lapointe?
Oui.
Mr. Lavoie?
Oui.
Mr. Nakvi?
Yes.
Mr. Chambers?
Yes.
Mr. Stevenson?
Yes.
Ms. Goodrich?
Yes.
Mr. Mantle?
Yes.
Mr. Savard-Tremblay?
oui.
Congratulations. Thank you very much. All right, on to Block 5, number
Merci d'être sorti de votre discrétion.
138-99223.
Thank you for the congratulations.
Like to speak to that as you enjoy your celebration there?
Oui, ben, écoutez, ben, je vais continuer.
Well, yes, listen. Thank you to my colleagues for remembering that what's good for Ukraine is good for Indonesia. So, because just last week, what's good for the UK should be good for Indonesia as well, notably this examination article.
Thank you very much.
Et je cite mes...
And I'll quote my colleagues from last week. They said it's a good idea, it's a precedent, we'll do it again.
Okay.
I'm a different person.
Any further discussion? Not seeing any. All those in favor of Block 5? Carried. All right. Thank you all very much. Now, since there are no amendments proposed from clauses 16 to 36, is there unanimous consent to group them for the vote? If yes, shall clauses 16 to 36 carry? Oui? Okay, thank you.
Non, attendez.
Okay.
Non, attendez.
Nope, no, hold on. It was 26 was ideated by our lovely civil servants.
Et je souhaite néanmoins... Non, moi, c'est le 26 que j'avais demandé au début.
No, that's 26. I wanted I wanted to know about 26, so I'd like to examine this further. I'd like to do a roll call on 26.
All right, so so I'll move from 16 to 25. All those in favor? Yes. So, and shall clause 26 carry? No. So you want to speak to
Je
it?
demandais un appel nominal.
I asked for a roll call, please.
So we'll have a vote on clause 26.
Shall Clause 26 carry? Mr. Fonseca?
Yes.
Madame Lapointe?
Oui.
Mr. Lavoie?
Oui.
Mr. Nakvi?
Yes.
Mr. Chambers?
Oui.
Mr. Stevenson?
Yes.
Ms. Goodrich?
Oui.
Mr. Mantle?
Yes.
Mr. Savard-Tremblay?
Non.
So the clause carries. All right, shall clauses 27 to 36 carry? All those in favor? Yes. All right, a new clause 36.1 for the block numbered 138-99626. If you would like to speak to it, Mr. Savard-Tremblay.
Oui, ben, c'est tout simplement, encore une fois...
Once again, it's to promote transparency and have updates. If we could have information on the results and costs that are ongoing related to LDI, we'd like that to be on an annual basis.
All right. Unfortunately, Mr. Savard-Tremblay, your winning cycle is possibly continuing, but I have to rule that the amendment is inadmissible. The Settlement of International Investment Disputes Act is not being amended by C-18, and it is therefore, in my opinion, that it is inadmissible.
C'est bon.
Please.
We know all the signs, right? Okay. All right. I have ruled that it is inadmissible. All those who want to support the chair will vote yes, and those who want to vote the chair down will vote no, just to be clear.
Shall the decision of the chair be sustained? Mr. Fonseca?
Yes.
Madame Lapointe?
Oui.
Monsieur Lavoie?
Oui.
Mr. Nakvi?
Yes.
Mr. Chambers?
No.
Mr. Stevenson?
No.
Ms. Goodrich?
No.
Mr. Mantle?
No.
Mr. Savard-Tremblay?
Ça veut dire
So that means no, yes, okay.
Your decision's overturned.
All right. So now we will have a vote on, is there any discussion on before we call for, the chair has, my ruling of it being inadmissible has been overturned, which now means that it's admissible and subject to a vote. Yes, Mr. Chambers.
Madam Chair, I hope you don't take the voting no personally.
Absolutely
that's
not.
good. Thank you. My read of the amendment is what I believe could be achieved through an order paper question within a quicker time frame than as proposed. So I appreciate the desire for more transparency, but I think we can achieve it through other means, non-legislative means.
Thank you. Mr. Mantle.
Thank you, Madam Chair. Question to our panel. In the first review of the NAFTA, which became the CUSMA, TMEC, USMCA, Canada was quite happy to drop ISDS as between Canada and the United States, given our record of losing most of those cases. Why then were we eager to include it in the CEPA with Indonesia?
Chair, I thank the member for the question. The question of which provisions are important to include in any given free trade agreement is a function of the bilateral relationship with that country in question, the issues that are likely to arise in the context of that bilateral commercial relationship, and the legal and regulatory regime that exists within the trading partner in question. In the context of the CUSMA review, I think there was a collective degree of comfort between Mexico, Canada, and the United States that North American legal and regulatory recourse was sufficient to deal with any issues that might arise with respect to the settlement of disputes related to investment. With respect to our other partners around the world, we make that evaluation on a case-by-case basis. In the case of Indonesia, there is significant Canadian investment in the Indonesian marketplace. We would, based on our consultations, those investors would appreciate having recourse to alternative dispute settlement, which can give them additional legal arguments to advance in a shorter time frame in many cases than domestic legal challenges would allow for. And so in the context of this agreement and in the context of the overall balance of concessions, we felt like this was a valuable provision to secure for Canadian investors operating in that economy.
So if I can translate, because you are quite eloquent, Mr. Fowler, you had some concerns perhaps with the domestic rule of law or other avenues for Canadian companies to avail themselves in Indonesia, and you wanted to maintain another option. Am I hearing that correctly?
I think you've perhaps put some words into my mouth that weren't there when I stopped talking, which is to say that we spoke to stakeholders who told us that they would value having alternative options to pursue any investment-related disputes that arose. We try, through our negotiations, to address the specific interests and sensitivities that our stakeholder community brings to our attention as negotiators. And in the context of this negotiation, we felt that it was possible to secure outcomes that would address those. And so because of the dynamics that were at play in these negotiations, we pushed for such an outcome.
So you thought those stakeholders' claims or requests were meritorious, and therefore you negotiated toward them.
That's right. We had no reason to question the considerations that informed the position the stakeholders were giving us.
Thanks.
Not seeing any further discussion, we'll call for a vote on block number 6.
Shall BQ6 carry? Mr. Fonseca?
No.
Madame Lapointe?
No.
Mr. Lavoie?
No.
Mr. Nakvi?
No.
Mr. Chambers?
No.
Mr. Stevenson?
No.
Ms. Goodrich?
No.
Mr. Mantle?
No.
Mr. Saval-Tremblay?
Oui.
Okay, the amendment fails. Okay, now there are no further amendments from 37 to 45. Do I have unanimous consent to group them for the vote? If yes, shall causes 37 to 45 carry? Yes, okay. Shall Schedule 1 carry? Shall Schedule 2 carry? Shall the short title carry? Shall the title carry? Shall the bill as amended carry?
Sur division.
On division.
Yes. There a concern here?
Sur division.
On division.
On division.
On division, okay. Shall the chair report the bill as amended to the House? Yes. Shall the committee order a reprint of the bill as amended for the use of the House at the report stage? Yes. Bill passed. Thank you all very much. Congratulations. You got a little bit through of extra things you wanted. Thank you all very much. The witnesses can continue on with your other responsibilities. Thank you all very much for your help in moving this forward. I believe there's been a request regarding the associate members motion from Mr. Chambers.
Madam Chair, may I just request? I would request or
Why don't
look
we
for consent.
brief
Just brief suspension.
suspension.
Maybe until the top of the hour.
Okay.
Which would then give us some opportunity to discuss our relevant motions.
All right. Thank you. Suspension for till noon. Mr. Chambers? I'm sorry, we call the meeting back to order? Okay, all right. Thank you very much. Just really quickly, we've all received a copy of a motion talking about adding up to three associate members per party at committees. Everybody has received it. Not seeing any objection, we'll adopt that motion to add the 3 additional associate members when necessary to the committee. All right, okay. Okay, all right, now, Mr. Navke.
Thank you, Chair. We have a sort of a programming motion, if I can call it, that to present that sort of brings together a few different motions that have been tabled in this committee that will allow us to do our work in a thoughtful way.
Just hold on, Mr. Navke. Yes.
Excusez-moi, parce que
That's a motion that was just distributed. I have one that's been waiting for December and another that's been waiting from the beginning of February.
Which?
Have we shared this with the clerk?
This is an updated motion. Same motion, just to change the date.
je sais, mais est-ce que les 2 que j'ai soumises,
I know, but the 2 that I submitted quite a while ago, are they going to have I would like them to have priority. Are they going to be considered?
So we're just getting into, that motion as far as adding associate members is not that's already been adopted by everyone. Mr. Navke signaled that he wanted the floor, and you have the floor, Mr. Navke. Please proceed.
Thank you, Chair. And a motion. This motion has been circulated. If you like, I can read the motion in its entirety as well for the record. Otherwise, if not, everyone has an English and French version of this motion, which simply is essentially adopts a work plan that puts in order.
Has that been distributed to the committee members?
It's been distributed to the clerk.
Well, just hold on a minute, okay? The clerk.
par courriel aussi?
We'd better. Okay. We're going to suspend for a couple of minutes, okay, until we make sure that everybody has the motion in front of them, please. Naviga, go back to you.
So I think you probably will find agreement between all members to adopt a work plan for this committee. We've done some remarkable work, and I want to really thank all the members for the work we've done. And this sort of really incorporates the priorities of all the members. So I ask for concurrence.
Okay. Mr. Chambers?
I appreciate the work that's been done. I would just mention that we have the CUSMA study that is open. So I would, this work plan does not take us all the way to June or to the end of the session. My recommendation would be is that we leave some time to include a meeting on CUSMA at a regular interval to keep that study going. But we're happy with the work plan as it appears.
Okay. All right. Not seeing any further discussion. Sorry, Mr. Mantle.
Can we know? It says we can't change it unless there's consensus.
Clarification. There's a clause in the motion or a section at the very end that indicates about a proposed ordering. If I would just, I'll
Say
leave it.
that again.
There's a clause in the after number 6.
In this
in the motion,
yes.
that talks about the listed order of the studies. It would be my preference to leave your judgment about scheduling,
Leave it open.
leave it open for you, just notwithstanding what it says in the motion, but in order to ensure that we have meetings and
continuation
witnesses
of
that
our-
you
of our
can,
different
you
work
can
plan.
start, you can start a
Yes.
study at any time of your choosing. But we can discuss that with amongst the parties, but that would be
Yeah.
a recommendation. The chair could use your discretion to deviate from that list as
So
necessary.
glad you have a little bit of confidence. Okay, thank you all very much. Move adjournment.